Good morning. I'm the Registrar Clerk for this matter. Justice Kalapa and all counsel are online. I call the matter of CCT-183-22J, Mabasutu Christiana Olasitse NO versus Minister of Police for judgment. Counsel are now invited to place themselves on record. Please note that this judgment is being recorded.
Morning, Justice. Appearance for the applicant, Advocate Mashudu Madi from the Johannesburg Bar.
Thank you. Noted.
Justice for the respondent, Paswani.
Thank you. I'll proceed. Today, the Constitutional Court hands down judgment in an application for leave to appeal against the judgment and order of the Supreme Court of Appeal. The applicant is Mabasutu Christina Olasitse, NO cited in her capacity as the duly appointed executrix in the deceased estate of Teboho P. Olasitse, the deceased. The respondent is the Minister of Police, cited in his official capacity. These proceedings relate to an incident that took place in May 2008, where a police task force conducted a large-scale operation in respect to vehicles and vehicle parts that had been stolen from police custody in the Northwest Province. Numerous members of the South African Police Services were involved in this operation, and after extensive investigation, some of those members of the SAPS were subsequently arrested, and some of whom were later charged, successfully prosecuted, and sentenced. The deceased, a then police officer stationed at the Mafikeng Police Station Vehicle Identification Section, was one of the members of the SAPS who were so arrested. The deceased was arrested by police officers without a warrant and detained on a charge of theft and corruption. The deceased was detained at the police station on 19th May 2008 and released on bail on the 29th of May 2008. On the 17th of May 2011, the charges against the deceased were formally withdrawn when the Director of Public Prosecution declined to proceed with the prosecution of the charges. On the 26th of May 2011, the deceased instituted action proceedings in the High Court of South Africa, Gauteng Division, Pretoria, under case number 29788 of 2011 against the respondent for payment of damages in the amount of 400,000 rands in respect of his alleged wrongful arrest and detention. The deceased alleged that he was arrested without a warrant by members of the SAPS, and at the time of his arrest, such members had no reasonable or probable cause for arresting him. On the 12th of December 2012, and while the finalization of the first action was still pending, the deceased instituted another action in the High Court under case number 71947 of 2012, claiming damages of 400,000 rands for malicious prosecution. On the 11th of May 2016, and following adjudication on a number of preliminary issues, the High Court awarded the deceased 90,000 rands in respect of damages occasioned by the unlawful detention of the deceased. In respect of the second action for malicious prosecution, the respondent filed a notice of objection on a point of law. The objection was premised on a submission that the deceased claim for malicious prosecution was a duplication of the first action and therefore offends the once and for all common law rule that obliges the claimant to claim all damages arising from one cause of action in a single action. The defendant reasoned that the award for the arrest and detention was compensation for all damages arising from the deceased's arrest, including loss of freedom and prosecution flowing therefrom. In adjudicating the second action for malicious prosecution, the High Court found that there was a significant overlap between the two claims of malicious prosecution and unlawful arrest, even though these claims amounted to two separate causes of action. As such, the High Court upheld the respondent's point of law and dismissed the applicant's claim based on the reasons that it defended the once and for all rule. The applicant appealed against the judgment and ordered the High Court in the Supreme Court of Appeal. The SCA accepted that there was a difference between a claim for malicious prosecution on the one hand and a claim for unlawful arrest and detention on the other. However, in this case, the SCA held that the difference pales into insignificance because the events that gave rise to the deceased's claim were the same. It held that the investigations conducted by the police officers formed the basis on which the decisions were taken to arrest, detain, and prosecute the deceased. Further, the SCA held that when the deceased filed the first action, it had all the necessary facts to institute a single action to recover damages and compensation for both the unlawful arrest and malicious prosecution. The deceased, according to the Supreme Court of Appeal, simply opted not to pursue the two actions simultaneously and was therefore barred from pursuing the second action separately, even though it is a separate cause of action when considering the once and for all rule. The Supreme Court of Appeal concluded that the High Court was correct in upholding the respondent's objection that the second action was a duplication of the first. It emphasized that despite there being two causes of action, the deceased was barred by the once and for all rule from instituting the second action. In the result, it dismissed the appeal on 15 June 2022 with no order as to costs. In this court, the applicant submits that by applying the once and for all rule to two causes of action, the High Court and the SCA have developed the common law without considering whether the rule suffered any deficiency that is at odds with the Constitution and the Bill of Rights. This, according to the applicant, is a constitutional issue that engages this court's jurisdiction. The applicant further argues that the matter raises an arguable point of law of general public importance. She contends that the question of whether the once and for all rule can be used to non-suit a subsequent claim based on a separate cause of action, albeit arising from the same set of facts, raises a novel question of law that transcends the interests of the litigants. On the merits, the applicant submits that there's a clear distinction between unlawful arrest and detention on the one hand and malicious prosecution on the other. She further submits that the material facts and the legal issues involved in each case are different and do not overlap. The applicant contends that the High Court and the SCA extended the application of the once and for all rule to two causes of action that arose from the same set of events and therefore gave rise to overlapping damages. The respondent contends that the judgments and orders of the High Court and the Supreme Court of Appeal are fact-specific and have no general application. As such, neither of the courts developed the once and for all rule. Sorry, can I ask people to please put your mics on mute, please? Thank you. I'll continue. Thank you. As such, neither of the courts developed the once and for all rule, as argued by the applicant. The respondent also submits that the applicant's argument on the development of the common law was raised for the first time in this court and should therefore not be considered by this court. The respondents further argue that even if the Supreme Court of Appeal's reasoning was incorrect, it would amount to a misapplication of the law to the facts of the case, which does not raise a constitutional issue. Lastly, the respondents submit that even if the matter did engage this court's jurisdiction within the meaning of Section 167, subsection 3b, it is not in the interest of justice for this court to engage in what would be a reappraisal of the issues already decided in the first action. In the majority judgment penned by my brother, Justice Makoka, with Deputy Chief Justice Meyer, myself, Justice Matlanga, Justice Majid, Justice Matopo, Justice Bottrell, and Justice Theron concurring, this court held that the issue of whether this court's constitutional jurisdiction is engaged raises a couple of sub-issues. The first is whether the applicant should be permitted to raise a constitutional issue for the first time in this court. The constitutional issue asserted for the first time before this court is the alleged development of the common law. It is now settled that the mere fact that a point of law is raised for the first time on appeal is not in itself sufficient reason for refusing to consider it. The proviso is that a party will not be permitted to raise a point that was not covered in the pleadings if its consideration will result in unfairness to the other party. In the present case, it is so that the issue was not pertinently raised in either the High Court or the Supreme Court of Appeal. But what is unique here is that the applicant's point of law is largely predicated on the holding by the Supreme Court of Appeal that the once and for all rule can be applied to two causes of action if they arise from the same facts. Also, there is neither unfairness nor prejudice to the respondent, as he has had the fullest opportunity to deal with the issue and does not contend otherwise. It is thus in the interest of justice that this point be considered by this court. The question is whether by applying the once and for all rule to two causes of action, the Supreme Court of Appeal merely misapplied the law, or whether it developed the common law. It is now tried that ordinarily the mere misapplication of an accepted common law rule by the lower courts does not raise a constitutional matter and thus does not engage the Constitutional Court's jurisdiction. In the matter of Villa Crop, this court held that the misapplication of the law ordinarily occurs when a legal standard that is correctly stated and adopted is then applied to the facts so as to derive a conclusion that cannot be sustained. But the adoption of an incorrect legal standard to decide a matter is not a misapplication of law, but an error of law. It is not a misapplication of the law because the decision does not proceed from a correct legal premise to an incorrect conclusion as a result of a failure to properly apply the law to the relevant facts. In the present matter, both the High Court and the SCA adopted an incorrect legal standard by applying the once and for all rule to facts to which the rule does not apply. That does not amount to a misapplication of law, but an error of law. In Bussack, this court held that the application of a legal rule by the Supreme Court of Appeal may constitute a constitutional matter if such application is inconsistent with some right or principle of the Constitution. Even if what happened in this case amounts to a misapplication of the law, which ordinarily does not engage this court's jurisdiction, such misapplication has impacted on the applicant's constitutional right of access to courts, contrary to Section 34 of the Constitution. Lastly, the question as to whether the once and for all rule can be applied to two causes of action is an arguable point of law of general public importance that transcends the interests of the parties. Thus, this court's extended jurisdiction in terms of Section 167 is also engaged. The determination of whether to grant leave to appeal is distinct from the consideration of jurisdiction and entails a discretionary exercise that necessitates assessing whether the interests of justice favor granting leave. An important consideration in this regard is that of prospects of success. The legal issue raised in this matter points to good prospects in both the High Court and the Supreme Court of Appeal developed the common law but failed to align such development with the Constitution. In all the circumstances, it is in the interest of justice for this court to grant leave to appeal and determine the appeal. As far as the merits of the appeal are concerned, what is in issue here is the ambit and application of the once and for all rule. The rule is derived from English law and requires that all claims generated by the same cause of action be instituted in one action. In Shembe, the appellate division explained the essence of the rule, stating that, quote, "The law requires a party with a single cause of action to claim in one and the same action whatever remedies the law accords him or her upon such cause," close quote. The court explained the ratio underlying the rule as follows. If a cause of action has previously been litigated between the parties, then a subsequent attempt by one to proceed against the other on the same cause for the same relief can be met by a defense of res judicata. The rationale is to prevent inextricable difficulties arising from discordant or conflicting decisions due to the same suit being aired more than once in different judicial proceedings or actions. Furthermore, the rule has its origin in considerations of public policy, which require that there should be a term set to litigation and that a party should not be twice harassed in respect of the same cause of action. Both the High Court and the Supreme Court of Appeal recognized that there was not one cause of action in respect of the applicant's claims, but two. In spite of this, they held that because they arose from the same set of facts, claims based on the two causes of action should have been instituted in one action. In reaching this conclusion, the SCA placed much reliance on the similarities in the applicant's pleadings in respect of the two claims. The premise of the Supreme Court of Appeal's reasoning is erroneous. The issue is not whether there are differences in how the two causes of action were pleaded in the respective particulars of claim. It is whether the two actions, as a matter of law, are based on two different causes of action and whether those causes of action have different elements. The elements of unlawful arrest and detention are A, arrest without lawful cause, and B, unlawful deprivation of liberty in the form of detention. In respect of arrest without a warrant, as was the case with the deceased, the arrest is presumed to be unlawful, and it is for a defendant to allege and prove the lawfulness of the arrest. In spite of the fact that the cause of action is the actio inuriarum, a claimant need not allege and prove the presence of animus inuriandi, which loosely translated means an intention to injure or consciousness of unlawfulness. On the other hand, malicious prosecution is constituted by A, setting the law in motion against the claimant, B, the lack of reasonable and probable cause on the part of the defendant, C, malice or animus inuriandi, and D, termination of criminal proceedings in the claimant's favor. As far as the onus is concerned here, unlike a claim based on unlawful arrest and detention, it rests on the claimant in respect of all the elements of the delict, including that of malice or animus inuriandi. Although in its judgment the High Court referred to these different elements of the two causes of action, it underplayed them. And the Supreme Court of Appeal did not consider them at all. Instead, both courts compared the allegations in the respective particulars of claim in the first and second actions. They considered the apparent similarities in the respective particulars of claim, and the fact that in both actions 400,000 rand was claimed to be key in determining whether the two actions ought to have been brought in a single action. This is what led the two courts into error. The cause of action is not determined by how a party frames his or her particulars of claim, but by the constitutive elements of a particular cause of action. The other consideration is that the two or more causes of action, although arising from the same set of facts, may not arise at the same time. Excuse me. For example, in the present case, the first action for unlawful arrest and detention arose immediately after the deceased was arrested and detained. From the beginning, the arrest and detention were either lawful or unlawful. But the second action based on malicious prosecution had not arisen then and could not be instituted at that stage, as the criminal charges against the deceased had not yet been withdrawn. This occurred almost 2 years later on the 17th of May 2011. There would also have been the risk of prescription of the first claim if the deceased was to wait for the termination of the criminal charges in order to combine the two claims in a single action. On the reasoning of the High Court and the Supreme Court of Appeal in the above scenario, the deceased would be barred from instituting the second action after the charges against him were withdrawn. Clearly, that would be absurd, as the second action could only competently be instituted once the charges were withdrawn. The other basis on which the High Court and the Supreme Court of Appeal rested their findings is the consideration of public policy factors, namely A, the possibility of double jeopardy against the respondent, B, the potential loss of available witnesses due to the fluxion of time, and C, the potential inconvenience to the respondent for putting him to the same expense incurred in defending the claim for unlawful arrest and detention. While these may well be legitimate concerns on the unique set of facts of this case, they should not be elevated to a general principle by which a litigant's right of access to courts is adversely affected. There are other procedural mechanisms in our law to address these concerns. For example, a court could deny a successful claimant the cost of the action. The reasoning and the judgments of the High Court and the Supreme Court of Appeal therefore marked a departure from how the once and for all rule has always been applied. Once both courts accepted there were two causes of action, as they did, they should have dismissed the respondent's objection on that basis, since the once and for all rule only applies in respect of a single cause of action. What the courts did was to apply the once and for all rule to the facts to which the rule did not apply, and thereby created an exception to the rule for cases where two or more actions arose from the same facts. This departure from how the rule had always been applied amounts to a development of the common law. However, such development was not undertaken in accordance with the Constitution, as neither the High Court nor the Supreme Court of Appeal embarked on an inquiry as to whether the common law rule suffered any sort of deficiency at odds with the Bill of Rights and thus necessitated its development. This court in DB, on behalf of WZ, set out the general approach to the development of the common law under Section 39, subsection 2 of the Constitution. In terms of that approach, a court must A, determine what the existing common law position is, B, consider its underlying rationale, C, inquire whether the rule offends Section 39, subsection 2 of the Constitution, D, if it does so offend, consider how development in accordance with Section 39, subsection 2 ought to take place, and E, consider the wider consequences of the proposed change on the relevant area of the law. The Supreme Court of Appeal considered none of these factors, nor the applicant's right. In terms of Section 34 of the Constitution, it is for these reasons that the appeal must be upheld. In a concurring judgment penned by the Chief Justice, he agrees with the conclusion reached by the first judgment that this court has jurisdiction and the order granted therein. He, however, prefers a shorter and, in his view, simple approach to dispose of the matter. This is owing to the increased caseload that the justices of this court carry since the expansion of this court's constitutional jurisdiction, and as such, the Chief Justice is of the view that one should adopt a shorter and maybe simpler approach or route to the determination of some of the matters that come before the court. The first judgment relied on the proposition that in deciding the matter in the way it did, the Supreme Court of Appeal developed the common law on the once and for all rule. That may be so, but the basis for jurisdiction that the Chief Justice prefers is Section 34 of the Constitution. The point is that the High Court refused to adjudicate the applicant's claim for malicious prosecution on the basis that it should have been included in the first action. The result is that the applicant's deceased husband's right to have the dispute between himself and the respondent adjudicated in a fair public hearing, which is entrenched in Section 34 of the Constitution, is implicated in this matter. That is a constitutional issue which engages the jurisdiction of the Constitutional Court. Just as a court may mare moto raise a point which suggests that it may not have jurisdiction or which limits its jurisdiction, it may also mare moto raise a point that suggests that it has jurisdiction. During the hearing of this matter, the Chief Justice raised with the parties the question whether it could not be said that this court has jurisdiction because the Supreme Court of Appeal's decision implicated the applicant's Section 34 right. Counsel did not challenge this proposition. As such, there is no unfairness in deciding the issue of jurisdiction on this basis because the issue was put to counsel and the point did not require any evidence or further affidavits. As far as the merits of the appeal are concerned, both the Supreme Court of Appeal and the High Court referred to and quoted authorities that stated that the once and for all rule applies where the same cause of action applies to both claims. Despite the fact that the High Court was aware that a single cause was the requirement for the application of the once and for all rule, it went on to hold that the rule applies to this case. The Supreme Court of Appeal dismissed the applicant's appeal on the basis that the once and for all rule applied to this case. In doing so, both courts failed to apply the authorities to which they referred and which were binding on them. For these reasons, the Chief Justice agrees with the order proposed in the first judgment. In the result, the following order is made. 1, leave to appeal is granted. 2, the appeal is upheld with cost, including the cost of 2 counsel. 3, the order granted by the Supreme Court of Appeal is set aside and replaced with the following, and I quote, 1, the appeal is upheld with cost, including cost of 2 counsel. 2, the order of the High Court is set aside and replaced with the following order. The respondent's objection on the point of law is dismissed with cost. And then paragraph 4, the matter is remitted to the High Court to adjudicate the applicant's claim for malicious prosecution. The judgment will be handed down electronically, I assume. That concludes the hand down of that judgment.
As the court please.
As the court pleases.
Judgment will be emailed to the parties and will be available online on platforms such as SAFLI. I call the matter of CCT-223-22 Robert Groves, the Minister of Police, for judgment. Counsel are now invited to place themselves on record. Please note that this judgment is being recorded.
Counsel, you've been invited to place yourself on record. Can you please proceed to do so?
I appear for the respondent in the matter, my lord.
Is that Advocate Madokwe?
Advocate.
Good, thank you.
Thank you, my lord.
Judge, I'm Franz Peterson. I have also appeared on behalf of the respondent in this matter. I'm lead counsel in this matter, but unfortunately, I will have to be excused in the next 10 minutes or so because I've got to attend to court. But Mr. Madokwe, if Madokwe will know the judgment on behalf of the respondents.
Okay, Mr. McKenzie placed himself on record or introduced himself earlier. Is that not in the same matter?
That is correct. Mr. McKenzie is for the
Applicant.
Appellant.
Okay, and
he's the attorney.
Okay, he's the attorney. Okay.
Yes.
Okay, that's fine, Mr. Peterson. Thank you.
Thank you, Judge.
Okay. Today, the Constitutional Court hands down a judgment in an application for leave to appeal against the judgment and order of the High Court of South Africa, Eastern Cape Division, Makanda, in brackets, the High Court. The substituted applicant is the widow and executrix of the estate of the late Mr. Groves, who passed away while the matter was pending in this court. Mr. Groves was arrested on the 26th of September 2016 following an undercover operation authorized in terms of Section 252A of the Criminal Procedure Act. The arrest took place in terms of an arrest warrant issued by a magistrate on application by a commissioned police officer. The warrant was sought on the basis, later established to have been mistaken, that Mr. Groves was the person who had sold the drugs to an undercover officer. The arrest of Mr. Groves was part of a larger operation. The investigating officer was Constable Dietrich. Mr. Groves' arrest was assigned to Warrant Officer Swanepoel. Warrant Officer Swanepoel did not have the docket with him, and he did not know the contents of the docket. When it emerged that the person who had sold the drugs was not Mr. Groves himself, although he was present, but Mr. Groves' brother, the prosecutor and Constable Dietrich was of the view that Mr. Groves had still facilitated the transaction. This view was, however, overruled and the charges were withdrawn. This led to Mr. Groves pursuing claims for unlawful and malicious arrest, detention, and prosecution in the regional court. These claims were dismissed in the regional court and on appeal to a full bench of the High Court. In this court, the applicant submitted that this matter raises several constitutional issues which engage our jurisdiction, including Mr. Groves' right to personal liberty under Section 12(1)(a) of the Constitution, and his right to be released under Section 35(1)(e) and (f). The applicant also argued that the punitive cost order raised a constitutional issue. The applicant further contended that this matter raised an arguable point of law which transcended the litigation interests of the parties and affected the public interest. The applicant narrowed the issue to unlawful arrest based on Warrant Officer Swanepoel not knowing he had and therefore not exercising a discretion. The applicant relied on the Supreme Court of Appeal's judgment in Minister of Safety and Security versus Sekoto in support of their claim that Warrant Officer Swanepoel had a discretion in terms of Section 43 of the CPA, and it was necessary for him to exercise that discretion when arresting Mr. Groves. The applicant submitted that discretion vested in a peace officer under Section 43, subsection 1 of the CPA when executing a warrant is no different from the discretion an officer exercises when making an arrest without a warrant under Section 40, subsection 1 of the CPA. The applicant contended that if Warrant Officer Swanepoel had exercised this discretion, Mr. Groves would not have been arrested because he was at home, and he was not a flight risk because he had an aerial around his leg as a result of a bullet wound. The fact that Warrant Officer Swanepoel admitted that he did not know he had a discretion showed that he did not exercise a discretion, and thus the arrest and subsequent detention were unlawful, says the applicant. The respondent submitted that only the issue of discretion engaged the court's jurisdiction. The respondents argued that the other issues raised by the applicant were arguments about supposed incorrect factual findings and thus did not engage the court's jurisdiction. The respondent submitted that under Section 44 of the Criminal Procedure Act, read with Section 43, subsection 2 thereof, it is clear that an arresting officer has no discretion and must effect the arrest. They argued that an officer's role is limited to A, ensuring that the person arrested is the one described in the warrant of arrest, and B, informing the arrested person of their right C. Bringing the arrested person before a lower court. The respondents argue that the arresting officer does not have a discretion because the magistrate is already required to exercise the discretion on the facts presented in order to issue the warrant. In a unanimous judgment penned by Pottrell AJ, this court finds that the matter does engage this court's jurisdiction because it raises an unresolved legal question relating to powers of arrest and detention on the strength of a warrant. This court finds that it is in the interest of justice to grant leave to appeal in order to adjudicate the question whether an arresting officer must exercise a discretion when arresting on the basis of a warrant. This court is further of the view that Section 43, subsection 2 of the CPA does not grant arresting officers a discretion whether to arrest or not, because the section uses shall rather than may. The use of may in Section 44 of the CPA relates to who has the power to execute the warrant and does not confer discretion when executing it. Therefore, there is no disconnect between Section 44, which determines who may arrest, and Section 43, subsection 2, which places an obligation on the officer to arrest under the terms of the warrant. This court finds that the statement in Sekoto referencing Groenewald as the Minister of Justice was erroneously referenced because Groenewald dealt with the discretion of a magistrate or peace officer applying for a warrant rather than the discretion of a peace officer making an arrest on the strength of a warrant. The factors laid out by the applicant to the effect that Mr. Groves was at home and was not a flight risk, and that he had an aerial around his leg, did not render the execution of the warrant irrational or without just cause. However, this court reverses the regional court punitive cost award because Mr. Groves' arrest was based on mistaken identity, and thus the regional court's finding that his claims were orchestrated were unsubstantiated. The issue of police discretion is of interest to persons arrested under the terms of warrant as well as police officers executing a warrant, and therefore a punitive cost award under these circumstances would be unfounded. In the premises, the following orders made. 1. The application for condonation and substitution are granted. 2. Leave to appeal is granted. 3. Save as set out in paragraph 4 below. The appeal is dismissed. 4. The cost order of the regional court is set aside and replaced with the following. Quote, the plaintiff is to pay the cost of the first and second defendant. Close quote. 5. There is no order as to costs in this court. That concludes the handout.
As the court please.
Judgment will be emailed to the parties and will be available online on platforms such as Safely. Today's proceeding